If USCIS denies your green card case, you may be going to deportation court. USCIS is issuing notices to appear in immigration court at record numbers, and we need to talk about it. You need to understand that if you're applying for an immigration benefit and you're out of status or you fall out of status while the case is pending, not only might you receive a denial notice, but you might also get a ticket to deportation court. And that ticket is called a notice to appear. Hi, I'm Jim Hacking, immigration lawyer practicing law throughout the United States out of our offices in St. Louis, San Diego, Washington, D.C., and Chicago, Illinois. But before we get to notices to appear, you need to understand how the different immigration agencies work together. After 9/11, the Immigration and Nationalization Service, INS, was broken up into different pieces and brought under the control of a new agency called the Department of Homeland Security, DHS. And under DHS are now 3 immigration agencies. The first, U.S. Citizenship and Immigration Services. That is the agency that is tasked with processing applications for immigration benefits like green cards, citizenship, asylum, work applications, those kinds of cases. The second agency, the part that broke off from Citizenship and Immigration Services, was ICE, Immigration and Customs Enforcement. And of course, you've heard of ICE in the news a lot lately. ICE is the agency that's tasked with gathering up people who are in the United States out of status and deporting them from the United States to their home countries. After ICE catches someone, they put them in the Executive Office for Immigration Review. That's deportation court. That is where you get to defend yourself from deportation, make whatever arguments, and try to stay in the United States. That's all still part of ICE. That's all still part of the deportation machine. The third part of immigration is Customs and Border Protection, CBP. So that's the people at the border who allow people into the United States or keep them outside the United States. And so when you know about USCIS, ICE, and CBP, and you know each of their responsibilities, then you know that historically, USCIS has been the nice part of immigration, processing benefits, and that Immigration and Customs Enforcement was looked at as a separate agency, and they were enforcement. So if someone was in the United States and they wanted to apply for adjustment of status, they would apply with USCIS, and USCIS would look at that petition, see if the evidence submitted warrants a favorable discretion and the granting of the benefit. So if somebody wanted a green card and they thought they were eligible, they would apply for a green card and they would do that with USCIS. One of the great benefits of marrying a U.S. citizen is that if you are out of status, that visa overstay is forgiven. So is any unauthorized work. So this is one of the reasons why USCIS looks so closely at marriage-based green card cases, because you're taking people from being out of status for having violated civil immigration laws and giving them lawful permanent resident status, which is just one rung below citizenship, which puts them on a path towards citizenship and really cleans up a lot of their problems. So one of the reasons USCIS looks at marriages so hard is because they want to make sure that this is not just to gain an immigration benefit to get the person out of immigration trouble, but rather because the couple loves each other, wants to live with each other for the rest of their lives. So the U.S. citizen files an I-130 petition, the foreign national files an I-45. USCIS has to decide, is this a real marriage? Is it one based on love? Do we believe this relationship? And then the second inquiry is into the 45. Is this person admissible? Are there any reasons why this person is not eligible for a green card, why they should not get a green card, and why we should deny their case? And historically, when USCIS denied a green card application to someone, if that person was out of status, they never really told the immigrant time for them to depart the United States, that because they have no real other status, that the proper remedy was for them to receive a notice to appear in deportation court. But that very rarely happened. It didn't happen much under President Bush or President Obama or President Trump in his first administration, or certainly with Joe Biden. For the last 15, 20 years, there have been case after case where people apply for an immigration benefit. They may be out of status at the time they apply, or they might be out of status while the case is pending. The case is denied, and many people are surprised to learn that when those cases were denied, the beneficiary, the foreign national, did not receive a notice to appear in the vast majority of cases. USCIS simply allowed the people to stay in the United States. Maybe they appealed, maybe they applied for another immigration benefit, maybe they got divorced, married somebody else, and filed a new green card case. Those days are over. And they're over because because USCIS has much more authority following a February 2025 memo that allows them and encourages them to issue notices to appear, which are that ticket to deportation court. So now that you know how the different agencies work together and how someone might apply for an immigration benefit and what might happen if their case is denied, now we need to talk about what is a notice to appear. A notice to appear is the legal document that USCIS, CBP, or ICE gives someone to let them know that they are in deportation proceedings. So when you receive a notice to appear, it will list your name, your alien number, your address, and then it will list certain allegations. And the allegations will go something like this. Your name is Jim Hacking. You are not a citizen of the United States. You are a citizen of Ireland. You entered the United States at some unknown date, and you entered the United States on a B1, B2 visa. That status has since expired. You are now subject to removal from the United States. The notice to appear then lists the statutory basis upon which you are supposed to be deported. Further down on the notice to appear is the date, location, and time of your deportation hearing, your first what's called a master calendar hearing. That's the first time you have to appear in front of an immigration judge. You're going to have to admit or deny each of the allegations that are contained in the notice to appear. So the judge will ask you, do you admit or deny allegation number 1? Do you admit or deny allegation number 2? And then the judge will ask whether you believe you are removable. The judge will then ask you, do you have any defenses to removal, like asylum or cancellation of removal, or the ability to adjust your status in immigration court? If you receive a notice to appear, that is a very serious matter. You will most likely be sent to the deportation court closest to your house as long as you have updated your address with USCIS. And so now in 2025, USCIS has been authorized to issue a greater number of notices to appear. And the reason for this is Donald Trump and the people behind Project 2025. So when Donald Trump was running for office, he said that he had nothing to do with the Project 2025 people, but since the day they came into office, they have been implementing everything out of Project 2025. And one of those points that they made was that USCIS should be issuing many, many more notices to appear, that we should be enforcing our immigration laws to the greatest extent possible, and that if we can find an immigrant who is inside the United States and who is out of status, that we can issue them a notice to appear and try to deport them as quickly as possible. You may recall the Republican National Convention when all the attendees were waving flags and banners that said mass deportations now, cheering on for Donald Trump as he said he was going to deport as many immigrants as possible. And that has now translated into policy at the Department of Homeland Security. And you have people like Thomas Homan and Stephen Miller who take the worldview that if an immigrant is inside the United States and their status has expired, that they should be deported. In fact, they have now created quotas for ICE officers, a certain number of cases that they have to put people into deportation on a daily, weekly, and monthly basis. And what better place to find immigrants than those trying to gain an immigration benefit through marriage or through their adult child inside the United States? The Department of Homeland Security knows that there are many immigrants in the United States who lack status but are trying to apply for a benefit because they are related to a U.S. citizen, either through marriage or through a family relationship. And so a little bit over a month after Donald Trump took office on February 28th, 2025, USCIS issued a policy memorandum, and in that policy memorandum, they made it clear that USCIS was going to significantly increase the number of notices to appear that it issued to people going through the immigration process. Basically, if you apply for an immigration benefit and at the end of that process, they conclude that you are not eligible for the benefit that you are seeking and that you have no status to be in the United States, that USCIS is now directed to issue you a notice to appear. And they listed many categories of people who should automatically get a notice to appear. And that would include people involved in fraud or deception, people who enter the United States illegally, people who lack any status in the United States, and people who have lost TPS, temporary protected status. But the big change comes in Part 6 of the February 28th, 2025 policy memorandum, and I want to read it for you here. It comes under the section, aliens not lawfully present in the United States or subject to other grounds of removability. USCIS will issue an NTA, that's a notice to appear, where upon issuance of an unfavorable decision on a benefit request, the alien is not lawfully present in the United States. So the default for every USCIS officer, if they have someone sitting across from them who is out of status and whose benefit is going to be denied, is to send them to deportation court, to issue them a notice to appear at some future date and to allow that immigrant to try to defend themselves from deportation from the United States. This is a huge change. Well, in the past, if you applied for an immigration benefit, say a green card based on marriage, and that case was denied, you might have another chance. You might be able to appeal. You might be able to file a second case. But now, USCIS officers are commanded to send you a notice to appear. Now you may be saying to yourself, Jim, they're not going to issue a notice to appear in every single case. They have to have some kind of a discretion. Well, this February 28th, 2025 memo includes a paragraph on prosecutorial discretion, and I want to read you the important part of it. An exercise of prosecutorial discretion to not issue an NTA, a notice to appear, should only be exercised in very limited and compelling instances and on a case-by-case basis after considering all USCIS and DHS guidance, DHS's enforcement priorities, the individual facts presented. So what that means is frontline officers are going to have very little discretion in deciding whether or not to give you a notice to appear in immigration court for possible deportation if you were out of status at the time you filed or are out of status as of the time that they adjudicate your application. Interestingly, such officers are going to have to get supervisor approval, and they're going to have to do it with DHS's stated objectives of deporting as many people as possible. And most importantly, USCIS and the Department of Homeland Security are going to track how often officers are deciding to not issue a notice to appear. The interesting thing there is that they're tracking it. They're keeping track of it. Their metrics are set up, and they're going to be evaluating officers on whether or not they are soft and not issuing enough notices to appear. So you know what that means? That means almost everybody's going to get a notice to appear, because that is how immigration officers will keep their bosses happy. Our team of attorneys have been discussing whether or not we think discretion is going to be granted in these cases, and we do think this is going to be an opportunity for us to really advocate for our clients in the hopes of helping people get through the process without receiving a notice to appear. And the greatest argument, I think, is that it just doesn't make a lot of sense, and here's why. If a U.S. citizen files an I-130 petition and the beneficiary is out of status, if the I-130 gets approved, which it should if the couple is in a valid marriage, but the immigrant is referred to the immigration court, then the immigrant will be able to adjust their status in court. So really all you're doing is kicking the can down the road, gumming up the immigration courts with more delays. The immigration judge could always send the case back to USCIS for USCIS to give lawful permanent resident status to decide the I-485. So there might be a circular argument here where things aren't really going to move forward. But of course, that's part of the deal. That's what they're after. They want immigrants to be scared. They want immigrants to think they're going to be deported. They want immigrants living in fear of that, and they want to add to the delay. How do we know that the Department of Homeland Security and USCIS are tracking how often officers issue notices to appear? Well, just a few months later, in June of 2025, they issued a press release. And in this press release, they touted how many green card cases were denied and how many notices to appear were issued by frontline USCIS officers. Here's what USCIS said. They had issued over 26,000 notices to appear between February and June of 2025. They said, under the new guidance, USCIS is generally defaulting toward issuing notices to appear after the issuance of an unfavorable decision on a benefit request where the alien is removable from the United States. In limited situations, USCIS exercise prosecutorial discretion. So you don't have to take my word for it. USCIS is flat out bragging in its press releases that they have greatly increased the number of notices to appear that are being issued on a weekly basis. The bragging continues. These screening and vetting efforts have led to approximately 1,840 NTAs a week and a 2,811% increase in fraud-related NTAs per month from the Biden-Harris administration era. This includes the issuance of approximately 500 asylum-related NTAs per week and 100 NTAs in temporary protected status cases per week. What do you make of that? Well, I'll tell you. We have an agency that has been basically co-opted by ICE, and USCIS is helping ICE meet its quota of finding immigrants to put into removal proceedings. So we are seeing in our office and on my Immigration Answer show that immigrants are receiving notices to appear before their interview, at their interview, or after their interview. So we have 6 groups of people that we need to think about. First are people who enter the United States on a visa. They were in status at the time that they applied, and they were in status on the day that the case was denied. For those people, they would not be put into removal. They would have another chance to file for a 485. They would have the opportunity to stay in the United States, and those cases would be treated as they've been treated for the last 10 or 20 years. Then we have people who are in status at the time of filing, but maybe their student visa ended or their visit visa ended, and all that they've been doing is writing their green card case. In other words, that's the only thing that's keeping them here. For those individuals, I believe that in most cases, USCIS is going to start issuing notices to appear so that they can issue more press releases, bragging and touting how many deportation cases they've started and what a great increase that's been over the Biden-Harris administration. The next group up, those people who are out of status at the time of filing. For these folks, I believe they will also receive a notice to appear. They will have to try to get their deportation deportation case paused or slowed down so that they can get their I-130 approved. With their I-130 approved, they may be able to go back to the judge and say, Judge, I'd like to adjust my status either here in court or back at USCIS. Could you terminate proceedings so that I can go back to USCIS and get my green card there and speed up your docket as well? Then we have a group that I think might be in real trouble, and that's people who entered on the Visa Waiver Program, or ESTA. Now, when you enter on the Visa Waiver Program, you have not been fully vetted by a consular official. You're allowed to come to the United States because you happen to have a passport from a certain country, and USCIS and CBP and the State Department have not all decided whether or not to let you into the United States. For those people, when you enter on Visa Waiver Program, you actually waive the right to see an immigration judge before being deported. So I believe that we may start seeing people who entered on Visa Waiver, who were out of status at the time that they applied, or have no longer any status because their Visa Waiver was only for 90 days. If their green card cases get denied, I do believe that we might start seeing cases of individuals being deported without ever getting to see an immigration judge, because when you enter on Visa Waiver, you waive that right. Then we have people who entered without inspection. I believe these people, simply by raising their hand, are going to be placed into deportation. They may even be subject to expedited removal. They might not get to see a judge depending on how long they've been in the United States. It's going to be a big old mess for those people, but they have to seriously consider whether it's even safe for them to apply for any immigration benefit at this stage. You may be thinking that they could be eligible for a waiver. However, the big thing to know about this whole policy is that Homeland Security and ICE are not going to wait for USCIS to take 2 or 3 years to adjudicate a waiver. They're going to deport that person and let the waiver work itself out, and then see if they let the person come back to the United States. The last thing we need to think about as it relates to this policy change is the idea of detention. Now, that's going to be a whole different video. We're going to have to do our own analysis and to see who starts getting put into immigration detention, but that's part of the process for some people, and we could see situations where people are not only receiving notices to appear, but they're also getting placed into deportation proceedings with detention, and that would be very, very sad for a lot of our clients or potential clients. My heart is breaking over all these changes. It's really a dark day for immigration and for people that want to do it the right way. USCIS, Homeland Security, and ICE are working together to conspire to stop legal immigration to the United States, which is part of what they were always planning to do. And if you find yourself wanting to go through the immigration process and now you're taking things a whole lot more seriously because you watched this video once or twice, then you want to think about hiring the best attorneys you can handle your case, and that would be us at Hacking Immigration Law. We'd love to work with you. You can contact us at 314-961-8200, or you can email us info@hackingimmigrationlaw.com. If you don't know this, I do an immigration answer show 3 or 4 times a week. That's just people coming to ask me immigration questions, asking me about their case. We've certainly been talking about this topic a lot lately, and you're free to join us there. We'd love to have you join us. You can text the word show, 314-470-3300. You would get an alert, a text whenever we go live if you're in the United States. You can also subscribe to the YouTube channel and turn on your alerts. You'll get alerted whenever we are about to go live or when we post a new video like this one. We also have a great Facebook group. It's called Immigrant Home. There's almost 16,000 people in there talking about the immigration process every day. And finally, if you're not following us on TikTok, you should, @Immigration Hacking. Thanks so much, and we'll see you next time.